Rise. Oh yes, oh yes, oh yes, the Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. We appreciate you being here today on this cold day for sure. I want to take just a few moments before we get started to make sure everybody is on the same page. First of all, I want to share with everyone that our proceedings are being live streamed. So if there's any question about anything that you should or should not discuss, you need to be sure and raise that in some motion before we get started. I've got veteran counsel here, excuse me, here today. So I'm sure you all know the rules, but basically a quick review is each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. You will need to request that from the court before you begin your oral argument, though. As far as timing, there is a monitor on the podium. That monitor has 3 lights, green, yellow, and red. As long as the light's green, you've got plenty of time. Once the light turns yellow, you're running out of time, and once the light is red, you are out. So we ask that you respect those time constraints. If you have any questions about the procedure today, you can discuss that with our Chief Deputy Clerk, Ms. Angie Dempsey, who's over here. Your panel this morning will be Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything before we call the first case?
No, Your Honor.
You may call the case, please.
City of Memphis versus George Edwards by and through Elizabeth W. Edwards.
Good morning, Your Honors. My name is Van Turner. For the City of Memphis, I'd like to reserve 3 minutes for rebuttal.
3 minutes?
Yes, sir.
Yes, sir. You may proceed.
Your Honors, may it please the court, Van Turner here for the City of Memphis. This is an appeal from an administrative law judge hearing. The City of Memphis denied benefits to the petitioner in this case, George Edwards. And in doing so, it stated a clear reason why it denied those benefits. Mr. Edwards had executed a settlement agreement. And in that settlement agreement, he took $17,000 and indicated in that release that he would pursue no further efforts to retain OJI benefits with the City of Memphis. Yet he did. And so...
Let me ask you, Mr. Turner, is that settlement agreement in the record?
Yes, Your Honor. And we'll get to that. I know there was a big issue from opposing side. And so, Your Honor, the record was never said not to be certified. In other words, when the petition was filed, the opposing side had the opportunity to submit and answer and affirmative defenses. And so that was never done. Both opposing side...
Which proceeding are you talking about now?
Your Honor, I'm sorry. I jumped from the administrative law judge proceeding to the Chancery Court proceeding.
Okay.
Yes, sir.
So let's be as precise as we can here because this
Right.
is a little bit confusing.
This settlement, was this settlement for specific injuries? I'm trying to understand the basis of the settlement.
So, yes, Your Honor, when an employee, especially if that employee is a firefighter or a policeman, if they develop a heart condition as a result of working with the City of Memphis, they can pursue an on-the-job injury claim, which is like workers' comp. And they're entitled to a presumption that if they develop that heart condition, it is presumed that it was because they were a police officer or a firefighter. And so they're entitled to the presumption, and they seek workers' comp from the City of Memphis, OJI. And when they do so, we can settle that, allow them into the plan, or deny them receiving the benefits. In this instance, we settled the claim with Mr. Edwards.
And it was for the heart condition?
It was for the heart condition.
And then allowed him to return to work?
Yes, if he wanted to. And so what happened was, in this instance, he filed another claim, a second claim for OJI benefits. And when that occurred, we denied.
For the same injury?
For the same injury.
Well, let me ask you this, Mr. Turner. If you can file a claim because of the heart, lung, hypertension-related issues, and you continue to work, if later there's an aggravation of that condition, are you precluded under the program for filing another claim?
You're not precluded on the program, but in this instance, Mr. Edwards signed a release. So he precluded himself. He said that he would, because of this lump sum of money, he would not pursue any further claims for OJI with the city of Memphis. And so he was...
For any kind of claim?
For any type of claims relating to the heart condition, Your Honor. So say if he had another injury, Your Honor, he could pursue another injury, but he cannot pursue the heart injury that he said he suffered.
Even if there's some aggravation of that condition because of his continued employment?
Your Honor, I think in this instance, there was a retirement, but notwithstanding that particular point, if he released his claims, then no. Because he said in his release that he would not pursue any other heart claims related to the issue that we were selling at the time.
I'm curious, the administrative law judge, he struck the settlement agreement,
Right.
which I think is sort of strange. Was there some determination that the settlement agreement was not drafted in a way that it would cover an aggravation of a condition?
No, sir, that's not why he struck it. He struck the settlement agreement because it was not presented in what was slated an affirmative defense by the city. And we get into that in the briefing. We were not required to present the settlement agreement in any type of affirmative
I think
pleading.
we understand that, Mr.
Yes, sir. So there was no need. We presented the settlement agreement at trial, and because it was quote-unquote a surprise, the court at that point struck it.
You're confusing me again, Mr. Turner.
What trial?
With the
I'm
court-
sorry, the administrative law judge trial. So at the administrative law judge hearing, Judge Stafford, the release was stricken because it was a surprise. And Your Honor indicated at that point that we should have presented that ahead of time. However, Mr. Edwards signed off on the agreement, and he received 2 letters saying, hey, you signed a release, why are you doing what you're doing? And he still pursued.
Okay, I don't want to mess up with your argument here, but now you've been ruled against with the ALJ.
Yes, sir.
What happens?
We appeal to the Chancery Court.
What happens here?
At the Chancery Court, Your Honor, we have everything except the hearing transcript. I think it was alpha reporting. And so opposing counsel and I both diligently pursued the hearing transcript. This was not anything the city held. It's a third-party transcriber, and they could not come up with it. We called every court reporter that we had used over and over again. We called all the other court reporting agencies that the city uses for these particular hearings. Nobody could locate the hearing transcript. Therefore, what was filed in the record, as you see, is a partial record. Only thing missing was the hearing transcript from the actual hearing. However, as argued in the briefing, the orders speak for themselves. There were 3 orders. One order that struck the release, a second order that awarded benefits, and then there was a final order. And so the argument to the chancellor was that everything is on file, including the orders, and all that's missing is the hearing transcript.
Okay,
Yes, sir.
work with me here. Are we talking about in the record before the Chancery Court, did you have the ALJ transcript? Is that what was missing?
Yes, the
Okay.
transcript.
Not the transcript before the chancellor.
No, sir. It was the
Okay.
transcript before the ALJ. That's what we could not locate. And it was done by a third-party
Could the
vendor.
parties not agree upon some statement of evidence or something akin to that?
Well, Your Honor, I put that forth as a compromise, and opposing side would not agree.
Did you submit one?
Did I submit a statement?
Yes, sir.
I did not submit a statement because there was no agreement by opposing side.
Do you have
as
to have
stipulated.
one?
Well, Your Honor, in this instance, I would say that we probably needed an agreement because everything else before the chancellor was something that I argue we had agreed upon.
Let me just, with that, this decision to strike the settlement, I mean, that issue seems like it's an issue of law. In other
Correct.
words, as to whether or not there was a settlement such that no further claims could be pursued. Was that settlement agreement in front of the chancellor?
Yes, Your Honor. It was, and that's what I argued in my briefing, that the hearing transcript was not necessary to determine if the stricken order was done so as an error of law. However, the chancellor indicated that because essentially we didn't produce the hearing transcript, there was no administrative record for him to decide the case upon, which we opposed because the crux of the appeal was that a signed release agreement with the copy of the check that was delivered to the petitioner was produced at the ALJ hearing and then produced for the chancellor.
Let me ask you a question about that. So the agreement is stricken by the ALJ. Is it stricken on a motion, an independent motion, or is it stricken as part of the proof that was submitted at trial after the ALJ heard the evidence?
It was stricken at trial by oral motion by
Did
opposing counsel.
And I'm sure obviously there's got to be some findings made by the ALJ,
Correct.
but, well, go ahead, I'm sorry.
And was the findings limited to this issue of your failure to submit that as an affirmative defense in writing?
Yes, Your Honor, it was that's how the order read. The order struck the release agreement because it was not presented pursuant to the rules as an affirmative defense, and it was untimely to argue the release at trial.
What
And-
rules?
Your Honor, the ALJ relied on Rule 803.
Did the rules apply to these proceedings?
The rules of civil procedure do apply to ALJ hearings. However, if you look at 803 and I believe Rule 12, basically what I argue was that all that was filed was a notice of appeal. There was no preceding pleading that was filed. In other words, there was no complaint or anything. They appealed, and basically we tried the case. So there was nothing to submit affirmative defenses to. There was no complaint at the ALJ stage. You just had a notice of appeal. We tried the case, and during the trial of the case at the ALJ stage, we produced the release.
So in other words, the rules apply, but they don't apply. In other words, there's no complaints required, no response, no answer to a complaint's required. Just a notice of appeal is required.
That's correct.
And you're not required to file a response.
Our argument is no. There was no response necessary. We denied the OJI claim. They appealed it. And the procedure was you're entitled to discovery if you want. You're entitled to depositions, but then you go to the ALJ and you try the case. That's what it came down to, and at that particular point when we were trying the
Is
case.
that always the way it's done then?
Yes, Your Honor. I've done this for at least 10 years, and I've never seen a notice filed, and then after you file a notice of appeal, you come forward with a complaint. Now, obviously, the city could ask for could file a motion for a statement, but I've never seen that done. You appeal, you take your medical proof, and you go try the case. And based on these arguments, Your Honors, we're asking that the Chancery Court decision be overturned. And I think I have 3 minutes. Thank you.
Yes, sir, you've got your rebuttal time.
May it please the court, Robert Spence on behalf of the appellee. We are before the court not on what occurred before the ALJ. We are before the court based on what occurred in Chancery Court. And the Chancery Court order that the city is appealing from is the order granting defendant's motion to dismiss for failure to file the administrative record. That is why we're here.
Did the chancellor ever address Mr. Turner's proposed argument? That is, that you can address the validity of this settlement agreement without the transcript?
No, none of that ever came up.
It was never raised?
It was never raised. We were before the Chancery Court, and after the petition was filed by the city, the statute requires that they file the record. Well, they didn't file the record. So we filed a motion demanding that they file the administrative record. When they did not file the administrative record, we filed a motion to dismiss. We then had discussions with the trial court about the missing administrative record. The trial court provided the city with 1 or 2 or 3 times to file the administrative record. And when the city could not file the administrative record, finally, then the parties briefed whether or not the trial court could adjudicate a review of an administrative decision in the absence of an administrative record. The trial court ruled that it could not. It dismissed the appeal, and that's how we got here. So that is the history of getting to this court.
Well, let me get more specific.
Yes, sir.
Was the issue of, or was the trial court ever asked to specifically review the validity of the proposed settlement agreement?
No.
It was never presented to the Chancery Court?
No. None of this is ever presented to the Chancery Court. The issue,
other than the fact that the transcript could not be presented.
and the record was not presented. So in addition,
Is there something except for the transcript? Because if I understood Mr. Turner correctly, the missing part of the puzzle here is the transcript.
the city never filed any record, including the transcripts.
Well, what did the city file
Well,
then?
how do we have the record then? How do we have this settlement agreement if it wasn't filed in the Chancery Court?
It was filed in the Chancery Court. After the case had been pending a while, Mr. Turner started filing pleadings in the record.
Well, then it was filed in the Chancery Court.
It was filed, but the city never filed the administrative record pursuant to 45322 that it is required to do, and we never agreed that the filings by Mr. Turner were complete. We can't prevent Mr. Turner from filing something with the clerk of the court, and he filed some things in the record, and so what?
When he filed those things in the record, was it for the purpose of the court considering those things that he was filing?
Yeah, and I'm not sure why he filed those things in the record. I think he was trying to cure the problem that he had, which was that the city of Memphis did not file a record. And so Mr. Turner was doing the best he could to try to create a record. I think that's why he did it. But at the end of the day, the city never filed a record. And so what you have before you is not the record. It's just some filings made by Mr. Turner, and there is no certification in this record from the city, which is required to do pursuant to the statute, that it has filed the record. So in addition to the pleadings and other documents not being in the complete record. We also don't have the transcripts from August 23rd, 2017, September 13th, 2017, November 20th, 2019. So none of that is in the record.
So what we're missing, Mr. Spence, is the testimony that was presented before the ALJ,
You are.
and that would have been what, the testimony of Mr. Edwards?
Not Mr. Edwards, it would have been the testimony of physicians, City of Memphis employees. It would have been that. It would have been that.
If the court had considered the settlement agreement and determined that the ALJ was incorrect in its legal decision to strike the settlement agreement because it in effect was dispositive of the case, would that have made a difference in this case?
Well, I think it would have made a difference for the city because they would have been the prevailing party. But the ALJ could not make that determination because there was no record, and the basis upon which the ALJ
couldn't make that decision, or the chancellor couldn't make that?
I'm sorry.
You said the ALJ couldn't make that decision.
No, the chancellor couldn't make that decision because there was no record, and the basis upon which he made that decision, the testimony from the city witnesses, wasn't before the chancellor. This issue about the striking of the settlement agreement came up during one of these hearings. And so it was all transcribed, and there was
Hearings
testimony.
in front of the ALJ
Right.
or the chancellor?
In front of the ALJ.
Okay.
There was never a hearing in front of the chancellor, but it was one of the hearings in front of the ALJ where this issue arose. The city presented some witnesses, the ALJ listened to the witnesses, the ALJ ultimately made a decision. That decision was that he was striking this late-produced agreement. And so none of that was ever heard by the Chancery Court because there is no record of those proceedings. So the Chancery Court never got around to trying to determine whether or not the ALJ made a legally incorrect decision because he did not have a record before him to review. In this instance, the Chancery Court was a reviewing court. It's a reviewing court. That's its role under 45322. And because the record of their proceedings and what occurred was not available to review, the order of December 21, 2021 was entered dismissing this appeal.
Let me ask you, at the
Yes, sir.
hearing before the ALJ, did you present proof to show that the nature of the injury complained of was somehow not covered by the settlement agreement?
I frankly don't recall. I don't think that we ever got that far. I think it was a procedural issue, but it's just memory and Mr. Turner's memory, and because there is no record. There is no record of what occurred, but my best memory, Your Honor, is that the issue had to do the dispositive way in which the administrative law judge dealt with the issue was procedural, not substantive. That's my best memory.
I know the ALJ's ruling in regard to striking the settlement agreement is in your favor, but under the rules, where you don't have a preceding pleading, are you required to file a written affirmative defense?
That was our position. Our position was that,
And what rule do you rely on for that position?
I'm not sure what rule we relied upon, because it's not what I rely on today, it's what I relied on then. And that record is not before us. We made an argument at the time that under the rules that we litigated the case before the ALJ, that the city had failed to comply, they had failed to disclose, they had failed to raise this agreement as a defense, and ultimately we prevailed.
How do you do that? I don't even understand how you do that if the process is as Mr. Turner described, that this whole matter came before the ALJ because you filed a notice of appeal for a hearing. You didn't file a complaint. He was not required to file an answer. So what would stop him from presenting this document to the ALJ? I'm unclear about that.
Well, I'm also unclear because I do not assign that Mr. Turner's memory is accurate. It's just what he's saying.
Forget his memory.
Okay, okay.
You've handled a number of these cases before the ALJ.
I have.
Do you agree that the procedure that he described is the procedure that you operate under?
No, I don't. No, I don't.
Did you file a complaint before the ALJ to follow up your notice of appeal? Was there a complaint for him to respond to?
Your Honor, I just don't recall because it's just not an issue. So I don't recall what all we did in 2015.
What do you normally do?
And normally I would file a complaint. I would file a pleading that would initiate a matter. So normally that's what I would do. But what I did in this case.
Was it a notice of appeal? Is that what you filed?
Your Honor, I just don't recall what I filed in this case. I know that we started the case. I know that we litigated the case. I know we began the trial of the case, and that this issue came up in the middle of the trial, and we then made a motion. There was argument, there was testimony, and the ALJ struck it. That's just based on my memory of what happened 5 years ago, but there's no record. And so, I mean, that's how we got here.
Let me move to another question.
Yes, sir.
What was filed by the city with the Chancery Court, other than the initial pleading saying, won't you review this?
After the initial petition was filed, then Mr. Turner filed in the record some of the pleadings that were presented to the ALJ. That's what he filed. And I think
so
that
the notice comes from the Chancery Court, says send the record up here.
yes,
And so what goes up there?
everything, the transcripts, every pleading that was filed. before
Right,
the-
what actually went up there?
Nothing.
Nothing.
Nothing. Nothing went up there by the city. Nothing. They didn't file a single shred of paper. Mr. Turner subsequently filed some pleadings in the record, but the city did not file a single sheet of paper, a single transcript, because I think Mr. Turner readily
You're
admits.
differentiating between Mr. Turner and the city here, but Mr. Turner was the city's attorney.
I understand, but the certification comes from a city, from the city, and even with regard to the few pleadings that Mr. Turner filed, he didn't certify anything. He just filed them. He just filed them. So there's no certification in this record at all.
So there was never anything filed from the hearing, from the board
Correct.
that goes up with some explanation.
Nothing was ever filed.
Okay.
Nothing was ever filed.
Was there ever a request to the chancellor to, based upon the unique facts and circumstances of this case, to consider this case on less than the entire record?
Not via a motion. There was much discussion with the chancellor about this unusual set of facts. But neither party ever filed a motion asking the chancellor to adjudicate this case based upon a hybrid record. It just didn't happen. the final point that I would make is that the city's brief doesn't comply with Rule 13B, in that the issues that it identifies is not commensurate with why we're here. And I believe that any issue about the propriety of the motion to dismiss has been waived pursuant to 13B, because the city doesn't even raise that as an issue in either one of the issues in its brief for this court to consider. Thank you.
Thank you. I believe you have 3 minutes, Mr. Turner.
Thank you, Your Honor. Your Honor, may it please the court, Van Turner again for the city of Memphis. In rebuttal, there are a couple of things to address. In the petition for judicial review, the main crux of the petition before the Chancery Court was the striking of the order.
Okay, that's a good point for us to start, because I want to follow up where I left with Mr. Spence.
Yes, sir.
At what point in time was the Chancery Court requested to do something other than what it normally did? In other words, to consider either this hybrid record or to consider only this issue?
Your Honor, in a pleading, I just looked at this. Further, plaintiff will offer that both parties could stipulate to the missing portions of the administrative record. The said proposed stipulation will recount the above stated fact pattern detailing the support for the administrative orders. In this matter, the stipulation would further then allow the parties to brief the court and proceed forward with the hearing despite not having the hearing transcripts. So this is something in the pleading that was filed by the city, plus this was articulated in the instances where we did approach the Chancery Court.
I understand in your discussions with the court, bench conferences, however you want to term those, but that would require stipulations, which you, I think in your earlier argument, you stated that opposing counsel would not agree to.
Correct.
So I'm struggling with, how do we hold, if there's error here, how do we hold a Chancery Court or any trial court in error when it was not requested to do the relief or perform the relief that is suggested here today?
You know, I think that relief was requested in the initiating petition. In the initiating petition for judicial review, the court was specifically requested to review the order striking the release, and that order was attached to the petition for judicial review. This has always been the issue that the city had, and this was always the issue presented to the court in all initiating pleadings. It was filed at the initiating stage. We were asking the court at the beginning to review the order striking the release. That's the sole reason why we obviously appealed the case. As far as...
Let me ask you this question. Mr. Spence has said that the city, I assume what he's talking about is the board itself, never transmitted any record to the Chancery Court.
That's absolutely incorrect. We did transmit the record.
Well, I'm differentiating between your client and the board here, okay?
Right. The client did submit the record, Your Honor, and the record...
Your client?
The city. The city presented the record from the ALJ hearings. And the point that I would want to make here is that at no point in time did opposing counsel move to strike the record. It only said we wanted the hearing transcripts.
What was in that record?
Your Honor, what was in the record were the pleadings and the orders and the medical transcripts, the deposition transcripts of the doctors, the orders from the ALJ, and all the pleadings that have been filed. The only thing missing in that what was filed were the hearing transcripts. But
Was that settlement agreement part of that record?
The settlement agreement was part of the record, and it was never moved by opposing counsel to strike what was submitted by the city.
So you're saying that there was a record
Correct.
that came from the city
Correct.
to the Chancery Court,
Yes.
and it included everything but the transcripts?
But the hearing transcripts, absolutely. Yes, sir.
That is not consistent with what Mr. Spence told this court.
Your Honor, this is the argument, and this, you have pleadings that are in this file. There was a record filed by the court, a record filed by the city. Opposing counsel never struck, never moved They never moved to strike what we filed, what the city filed. It only moved to say, we don't have the hearing transcripts, therefore the administrative record is not complete.
One final question. At the hearing, of course, you don't have any transcript of it, was there proof presented to show that the injury complained of was not covered by the settlement agreement?
There was no proof to that. Essentially, Your Honor, what occurred at the hearing was that at the beginning, we presented the release and we asked for the notice to be dismissed because this release covered the same exact injuries which had occurred back in 2004.
And did you put on proof to establish that it was the same injury?
There is proof in the medical file. Yes, sir. We do have depositions which were filed with the ALJ, which indicated, the doctor indicated that the same injury complained of now, I think it was 2012, was the same injury that was complained of in 2004, which was subject to the 2008 release and settlement.
Without aggravation of that 2005 injury?
Correct.
Was that deposition part of the record?
Yes, sir.
Was that part of the record before the Chancery Court?
Yes, sir.
All right, thank you. Thank you,
Thank you,
counsel.
Your Honor.
We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time.
Thank you, Your Honors.